I'm gonna keep on a-walking, keep on a-talking, marching up the freedom with voter suppression. Ain't gonna let voter suppression turn me around. Oh, turn me around. Oh, turn me around. Ain't gonna let voter suppression turn me around. I'm gonna keep on a-walking, keep on a-talking, marching up the freedom way. Let me ask the pastor if he would welcome us here, and let's thank God for him today and for the 3rd Street AME Church.
Thank you. Amen. I'm so glad to know that I'm in the midst of people that believe that it's going to be all right. Amen. Amen. Truly, I'm Pastor Reuben Boyd, and the pastor of this historical church, 3rd Street Bethel African Methodist Episcopal Church. I hear somebody say Zion. It's not Zion. No. Amen. No. That's all right. They are cousins. But we are happy to have you here to welcome you in today, Dr. Barber and this delegation. And I'm especially happy to have you because I am a North Carolina man. Amen. I've been here in Richmond now about 4 years, so I am so happy. That's why when I was asked if we could do this, I was glad to do it, to have my North Carolina people coming, my brothers and sisters. So again, my brothers and sisters, on behalf of this historical church here that's been here for 165 years, we truly welcome you in and glad that you can spend this time with us. Amen. 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 God bless you.
Amen. Let's thank the pastor. Amen. Thank you, Pastor. The order of today is, I want to first of all recognize the State Conference President of Virginia. She's going to come at another point and give remarks. Let's give her a hand. Amen. Our State Conference President. And also we have in our midst 2 national board members of the NAACP, and Ms. Deborah Brown, who's from Virginia. Amen. And the Assistant Secretary of the board and a warrior in the fight for justice, Sister Carolyn Q. Coleman. Amen. Also have today, traveling from North Carolina, we have our Vice President Carolyn McDougall, whose district is greatly impacted by these laws. Vice President Courtney Patterson, who's also districts are greatly impacted, and Vice President Reverend Dr. T. Anthony Spearman. They are all here. In fact, with Ms. Coleman, that means we have the full contingency of our vice presidents that are here today. My name is Reverend Dr. William J. Barber II. I'm president of the North Carolina NAACP. We also have critical members of our staff team who are here. We have Reverend Curtis Gatewood, who's serving now as our field director. Reverend Gatewood. Thank you. We also have Ms. Laura Ashton, who is working hard as our Western coordinator field coordinator for the NAACP. She's a field secretary, actually. And is Kayla here? Kayla, did she leave? Kayla, where's Tyler? Tyler is working with our media. And Kayla, is Kayla here? Kayla, she's in the back. Kayla is one of our new consultants we've just hired to do voter registration. And we have the regional director, amen, for this region, who's here as well. And we thank God for him. And now we have just had to arrive Penderhare, who is the lead attorney in the case of North Carolina NAACP versus McCrory, who also shares that distinction with none other than attorney Allison Riggs. Where's my friend from the law? I'm going to have you in a minute introduce all the lawyers, okay? Who are here. But I do want to say something. You know, today when I looked at Ms. Coleman, and we have our 3 lead plaintiffs here today. Ms. Rosanelle Eaton, right here. who is somewhere around 49, 50 years old. I may have that inverted. And we have Miss Mary Perry, who, how long were you a president? She was the president of a local track for 41 years. And she's one of the lead plaintiffs. And of course, Miss Carolyn Q. Coleman, who I like to say has worked every area of the NAACP, youth all the way up. She was there in Memphis when Dr. King was there, when Dr. King was killed. Tremendous history. These are the three matriarchs that made up the core of our plaintiffs. And there were many other plaintiffs, but they made up the core. And I'm so thankful. And I saw today, as we begin this press conference, and I'm going to call on Penda and then call on Allison, and then we'll take questions from the media, and then have some comments from our state president. Just the picture in the courtroom. I don't mean this with any disrespect, but I couldn't help but recognize it. Here we are in the capital of the old Confederacy. And those who were defending the voter suppression were all white men. And those who stood up to stand against voter suppression were 3 women in full diversity. Huh? You had little Asian, little white, little black, all that mixed in up there. Standing up. I couldn't help but believe that the ancestors were proud. And then you looked sitting there. You had African American, you had African, you had white male, you had young people. Here in the old cradle of the Confederacy. Now, one thing I want to say to the members of the media, let's be clear what this is really about. In 1968, 3 years after the Voting Rights Act was signed, and Lyndon Baines Johnson said that the Voting Rights Act was as important as any victory we had ever won on the battlefield. Kevin Phillips came up with a plan called the White Southern Strategy. George Wallace first tried to use it, but they said he was the greatest loser of all time because he showed Richard Nixon and other folk how to use it. In fact, if you really want to understand Trump, go read George Wallace's speech in 1968 in Madison Square Garden. Same language, same kind of attacks, same kind of divisive rhetoric. In fact, one of the ways of the White Southern Strategy is to use code words that don't sound racist, sound rational. You heard that in the courtroom today. But actually, that rationale is the rationale of racism, and it's the politics of race. So Kevin Phillips said to the people, we can win. We can take over the South, and that way we can control the nation. But this is how we have to do it. We have to find out who doesn't like who and pit them against each other. We've got to make poor whites in the South distrust African Americans, Latinos, and believe that their problems are the result of black and white, brown people somehow getting certain things. So they wrote a code. Lee Atwater, who was the campaign manager for George Bush, who played the Willie Horton race card, was on tape one day. He asked this reporter, you have this on tape? He said, yes. He said, you're not going to do anything with it. Well, the reporter didn't answer, which means he could do something with it afterwards. And Lee Atwater, if you listen to that tape, went on to say, he said, this is what we decided. He said, we decided after 1954, we couldn't use words like the N-word. That's too overt. That's too, people know that. You have to use code words. So we'll start using code words like cutting taxes, states' rights, entitlement reform. Doesn't sound racist. You could hear Attorney Farr trying to make that same claim today. I heard it, because when you know the thesaurus of the White Southern Strategy, you hear it. The untrained ear, Dr. Allison, doesn't know it. But the trained ear knows that that's code language. Just like when you call the president a food stamp president. When you say that you want to put up walls. When you say that you want to, that people, you don't need a living wage. You're not saying a racially tainted word, but you're suggesting policies that will have a disparate impact on black, brown, and poor white people but you say it in a way that poor white people miss it. And so Nixon used it and won overwhelmingly in the South. He used that strategy. Now understand this history. When George Herbert Walker Bush, Daddy Bush, first ran for Congress, he actually said, when somebody asked him about the 14th, the Civil Rights Act, he said, I'm concerned about the 86%, not the 14% that are impacted by the Civil Rights Act. Ronald Reagan said when he ran using the Southern strategy that the Voting Rights Act was a violation of states' rights. So this animosity against voter suppression began immediately after the Voting Rights Act was signed in 1965. And the Southern strategy was developed after 1968 to use this coded language so that when people go into court, they can say, well, this was just a rational thing to do. It wasn't racial. And the goal was to find out a way to separate blacks and whites in the South from building fusion coalition, because protecting voting rights that impact black people is not just about black people. We have the disparate impact, but it actually undermines the democracy. It undermines the ability of blacks and whites to be a fusion coalition, because those who are afraid of fusion coalition know the power of it. Like in the 1800s when black and whites came together from Virginia to Mississippi after the Civil War and changed this country because they changed the South. So, since 65, the Voting Rights Act has been under attack. Since around 68, the goal has been to control 11 southern states, especially, not only those, but especially, why 11? Those are the former Confederate states. And I thought about that being in Richmond today. Here's the dynamic, the members of the media. If you can control the election in 11 southern states, from Virginia to Mississippi, this is what you control: 22 U.S. senators, which means you only need 4 more senators from the other 39 states to control the United States Senate. If you control the 11 southern states, Ms. Coleman, you control 31% of the United States House of Representatives, which means you only need 20% from the other 39 states to control the Congress. If you control the 11 southern states, you control 162 electoral votes. You only need 270 to win. So if you control 100 and just say 60, then that means you only need 110 from the other 39 states. Voter suppression and attacks on the Voting Rights Act has always been about controlling the South and controlling other parts of the nation in order to dominate the democracy. It's always been about that. We have to understand the context. So in 1965, when the Voting Rights Act was passed, it was not as though everything suddenly got better. It wasn't until 1990 that North Carolina had another U.S. congressperson to return to the United States Congress after the last one had been forced out in 1901, which meant it was 25 years after the signing of the Voting Rights Act before North Carolina even had representation in the United States Congress. It was 25 years before many of the beginnings of the voting opportunities that our legislature is now trying to overturn were first put in place. It was the 1990s when we first started talking about early voting. It took us another, 18 years, 2007, to pass same-day registration and early voting. It wasn't as though people hadn't been working on it. This is even with Democrats in office. The NAACP had to challenge Democrats 30 times since the Civil Rights Act. It's not just about party, it's the politics of race. It's the politics of control. And so what happened was in 2010, I'm trying to tell you how we got to this courtroom. In 2010, in the backlash against President Obama, because President Obama ends up winning Virginia, North Carolina, and Florida, his electorate, not him, the electorate broke through in the South. That wasn't supposed to happen because the South was supposed to be solid. But he broke through in North Carolina, broke through in South Carolina, broke through in Florida, broke through in Virginia. That scared the proponents of the Southern strategy because it showed them that the South was no longer solid. Statistics began to come out that if you register 600, that if you register 10%, 30% of the unregistered black voters in the South and they vote, you begin to change fundamentally the South. And if they hook up with Latinos and hook up with progressive whites, you really have changed the South. So in the backlash, the goal was let's control state legislatures. All the focus in 2010 was on state legislatures. Let's control state legislatures in a time when the voting is down because the 2010 redistricting is coming up. And when that happened and they won a majority, now watch this, the governor had no veto of redistricting. The governor can veto the voting bill but not redistricting. And so the legislature then went on to pass in 2010 the worst redistricting plan in North Carolina since the 19th century, not the 20th, since the 19th century. They stacked and packed 51% of African American voters into 27 out of 120 state house seats, districts, and they packed 49.7% of blacks into 19 out of 50 state Senate seats, thereby creating apartheid redistricting, which stacked, packed, and bleached the black vote, not just to undermine the ability of blacks to elect candidates of choice, because they knew they couldn't take our seats away from us, but what they wanted to do was disempower the ability of blacks, brown people, and progressive whites to form coalition. That produced a supermajority. It also meant that our United States Congress representation went from 7-6 Democrat to 10 Republicans and 3 Democrats because of apartheid redistricting. Yes. And then the 2012 elections with these apartheid redistricting. And they get elected a supermajority, not because they won, because actually 100,000 more people voted for progressives than they did extremists, but because of the redistricting, they win a supermajority. And on day one, in the first 50 days, they began to roll back everything that the progressive community had won. They denied Medicaid expansion. They denied 900,000 people earned income tax credit. They cut $1 billion from public education. I'm talking about North Carolina. And North Carolina becomes an experiment because it's considered kind of like Virginia, progressive state. So if you can be regressive in North Carolina and Virginia, then you can spread it around and get away with it. Then during Monday, Thursday, during Holy Week, is when they first filed the first attempt at a voter suppression bill. During the same week that we were thinking about Bloody Sunday, they filed a couple of bills. One of them was Senate Bill 666. Father didn't want to talk about that. They filed that bill, but then they sat it aside. They filed a photo ID bill and passed it on the House side, and we were in the courtroom the day that Mickey Michelle stood up as a former Solicitor General. Am I right? Former Solicitor General, former U.S. State's Attorney, excuse me, and had the Constitution of North Carolina in his hand and said, I want to read what it says in Article 6 about voting, and Tom Tillis ruled him out of order. I was there. Tom Tillis said, that is out of, and Representative Shaw said, but I'm reading the Constitution in a body established by the Constitution. And to uphold it, and he was ruled out of order. They passed voter ID. Then they sat it down. They didn't move it to the Senate because they wanted the media to call this bill a photo ID bill. So that's what everybody did. Then June 25th happens. In fact, between that time, there were a whole lot of arrests by some people. I see some of them around here, called Moral Monday. June 25th happens. the Shelby decision comes down. Senator Apodaca says now that the headache has been removed. What headache is he talking about? Is he talking about the Voting Rights Act? Is he calling that a headache? Isn't that the bill that was signed in the blood of Medgar Evers? Isn't that the bill that was signed in the blood of Swanner, Cheney, and Goodman? You mean that's a headache? He said, now that the headache has been removed, we can move forward with the whole bill. And House Bill 589 went from photo ID to an all-out voter suppression bill like we had not seen since Jim Crow. Now, Jim Crow didn't do it like Jim Crow did in the old days, put on masks and stuff. Jim Crow put on a suit, got in the back room with a computer, and the only data they had was race. Not party, race. And you heard them admit today, they knew. They knew. They requested the information. They said, give us the information of how this is impacting people by race. And then that information they had it, and they used it after Shelby, because prior to Shelby, none of what they did would have passed pre-clearance. None of it would have passed pre-clearance. But after Shelby, the burden switches from them to prove that it's not racist on the front end to us having to prove it on the back end. So we've actually been operating elections in North Carolina, we believe, with laws that are unconstitutional. And districts that are unconstitutional because the courts are now saying so. Now, we filed almost immediately. Remember that, Pender? The ink hadn't even dried. It was 42 and a half minutes, I think, after they signed. I know it was quick. Remember? That we signed, and this coalition came together because we recognized we had to come together like this. Southern Coalition, Nita Earls, and Pender Hare, and even this law firm from way up yonder in the north. They didn't come down to be carpetbaggers and take money out. They brought some resources in. Huh? And then the U.S. Department of Justice came on. Because here's in my last comment, here's where we are. This was the first and the worst case after Shelby. That's why there's not a lot of record on, because nobody had the audacity to do this as long as the Voting Rights Act was fully empowered. This is the first. This is the test, members of the media. This is the test. And what is the test? The test is this: retrogression. That is not allowed. Can a political body, simply because they have a majority, and simply because they say they have rational reasonings for doing it, which means that doesn't mean it's racist, can they retrogress? Can they take from citizens, particularly African Americans and Latino, opportunities that have been placed in the voting procedures to overcome past and present obstacles? Can they, simply because of a desire to do so, to suppress certain people's vote, retrogress? That's the question. Because if that becomes the question for America, that means Ms. Coleman, Ms. Eaton, Ms. Perry, Ms. Allison, all of y'all, everything you all fought for can be overturned by a simple majority. Even when you know that the pretext is race. Retrogression is dangerous for America. That's what we have done. This case is not just about North Carolina. It is about a case where you have evidence of what is going to happen if you do this. You have evidence that the things you're going to undo have positively impacted African Americans and increased voting from 42% to 70%. North Carolina had gone from one of the lowest in the country to the fourth highest per capita increase. You have evidence of disparate impact. You know that early voting, same-day registration out of precinct, registering 16 to 17-year-olds, and strict form of voter ID will hurt the African-American and brown and poor community. But as soon as the court nullifies Section 5, you say, we are going to use that as a signal that our hands have been untied and our darkest imaginations can be brought to life. That's the question. Is America a place of retrogression? And we've never seen this except at the end of the first Reconstruction in the 1800s, when Southern legislators and others went backwards after all the progress. That's what's before us. And that's why this issue is about black and white, Latino. It is about the fundamental heart of our democracy. Yes. Is retrogression going to now be the law of the land? Can you walk back across the Edmonds-Pettus Bridge? That's the question. Can you walk back through the blood of the martyrs? Can you do it and simply say, even though we knew it would hurt certain people, it's okay because we had the political majority? Can a political majority run roughshod over a minority? If that's true, then the Constitution is invalidated. Because the point of the Constitution is to protect the minority from the abuse of the majority. And this legislature took extraordinary measures. I got that from him. Extraordinary measures to suppress the vote. Now here's the second thing, and I'm through. Not only is it retrogression, this case proves the need for restoration. This case proves that the Supreme Court was wrong in Shelby. That Section 4 should have not been nullified, which thereby disabled Section 5, which thereby disabled preclearance, which thereby enabled legislators and governors across the South and across the country that were covered by Section 5 to retrogress. And here is another startling reality. We're in the cradle of the Confederacy, former capital. Today is Tuesday. Saturday is June the 25th. That will be 1,095 days since Shelby. The 15th Amendment says that the Congress is supposed to fix these laws. So that means that Mitch McConnell and Boehner and Ryan have sat on fixing the Voting Rights Act, Section 4, so that Section 5 would be reinstituted for nearly 1,095 days. That means we've had a 1,095-day filibuster in the Congress. That is 1,094 days longer than Strom Thurmond filibustered the 1957 Civil Rights Act. And that means that we are headed into the first presidential election since August 1965 without the full protections of the Voting Rights Act. And not one party, Democrat or Republican, has had a debate on voting rights. Not one presidential candidate. They call major speeches on national security. They call major speeches to talk about each other. But not one has said, today I'm inviting all the media to talk about voter suppression, racism, not what somebody calls you, but institutional racism. Not are they racist in their heart. That's not where you prove racism. You prove racism in your policy. There's not been a major national conversation on the state of voting. And voting is at the heart of democracy. How can you ask people to vote for you and not even talk about voter suppression? And I'm not talking about in passing. I'm not talking about mentioning it among other things. I'm talking about like President Obama did that time when he had one speech on race and was pushed. And so now we need to be calling for immediate passage of the Voting Rights Advancement Act. And we who are advocates cannot be quiet on this. We cannot be quiet on this anymore. We cannot be quiet on this. Because if if this is allowed, then we are in 1869. Because 1870 is when the 15th Amendment was first approved. And if you're saying now in America that you can not only deny, but abridge voting rights, then that puts us back to 1869. That is why I am glad to welcome to this podium what I would call modern day Shipra and Puah. In the Bible, there would have been no Moses without two women who stood up to Pharaoh and challenged Pharaoh. Their names were Shipra and Puah. Today, in the courtroom, their name was Penda and Allison.
Thank you, Reverend Barber. Today, it is an honor and a privilege, and I thank you for allowing me to serve as your attorney in this historic case, challenging, as Reverend Barber said, the heart of voter suppression that has been renewed in this country in the last few years. And I want to thank particularly the plaintiffs, all of you, and our three sheroes, Mrs. Coleman, Mrs. Perry, and Mrs. Eaton. Because our job as lawyers really is just to be the vehicle to tell your story. And what their stories and all of the stories of the witnesses, the powerful witnesses that we presented in the district court show, is they faced the atrocities of the earlier round of voter suppression in the last century. And now what they are living to see is the current round, that history repeating itself. And they have once again come forward to say no, not on our watch. And so today, despite the very, very powerful evidence that with all of you we presented in Winston-Salem, we got the decision in April, and it was a very big disappointment. But as we read it, we immediately saw the errors that would give us grounds to appeal. So today, all of us took the historic step of taking this case to the Court of Appeals for the Fourth Circuit here in Richmond and presenting it and asking the court to overturn the district court and to declare that the legislature that enacted House Bill 589 acted with intent to discriminate. With intent and purposeful intent to take away the rights of African Americans because of how they vote. And we also invoke the results test under Section 2 of the Voting Rights Act, which doesn't require proof of intent because Congress made the decision that if it results in discrimination, then it is illegal regardless of intent. That's right. And it was a joy and a privilege to work with Ms. Riggs and Ms. Baldwin in preparing and presenting this argument, and the two of them were spectacular as representatives of this cause. And I also just want to close by thanking all of the lawyers who have worked so hard on this case since 2013. Michael Glick is here representing our co-counsel, the law firm of Kirkland and Ellis that brought enormous resources into this case. They have just done a spectacular job, and I think we have really converted them now into voting rights lawyers forever. And then I want to also thank Irv Joyner and Adam Stein, our North Carolina co-counsel. And we also have here Denise and Danita, our colleagues from Advancement Project, and then Caitlin and Rochelle and Valerie from my organization. And I know that all of us who have worked on this case, it has just been such a joy and really an honor. And I never predict how cases are going to come out, but I will say that I believe that we have a very, very strong case. Yeah. Thank you.
I want to thank you all for coming today, especially those of you who've traveled long distances. It matters to judges to see people in the courtroom who care about outcomes. And it matters that was a cross-racial coalition of advocates sitting behind us as we argued technical parts of the law. Because I think if you were sitting in that courtroom, hopefully you walked away concluding that the law is on our side, but history is on our side. And the moral right of North Carolinians to build our democracy, to build a more inclusive democracy, is on our side. And it meant a lot to the entire team, who've already been thanked, I won't repeat. But it meant a lot to the entire team that everyone was there in support of us. So thank you.
Now what we want to do at this point, and Michael is being modest, but let's be honest, if what's that whole name? Y'all got the long name.
Kirkland and Ellis.
Kirkland and Ellis, just let's be real, y'all. We do a lot of fighting, but we ain't got a lot of money. But we found out if we fight right, somehow the Lord will send what we need. And Kirkland and Ellis was a godsend. They don't normally do this kind of law, but they said they want to do it, and they wanted to come alongside us pro bono, and they provided enormous amounts. Pender Hare was the one that went out and found them and brought them to the table because, you know, mean policies have money, so moral policies need some money. And they brought a whole, as my grandma used to say, a whole passel of lawyers. Whatever passel means, you know. And they've been there, and I can tell you, Mike was often the one that would get me straight and ready for trial. He's hard. He's a hard dude, but we thank God for all of them. Let's field questions now. Allison and Pender, if you all will come. Are there any questions from member of the media? All right. Yes, sir.
Colonel Barber, based on what we heard in the courtroom regarding this whole election coming 20 weeks from today, are you concerned about this timetable of sorts as the attorneys representing the state of North Carolina said, hey, things have to be printed, computer programs have to be carried out? Is this a race against time, or were they describing it as stall time?
Well, you know, I'm glad you raised that, because it's eerie how you hear stuff from the past brought into the present. For instance, I remember in the judges respectfully say that when he wrote his opinion to almost more than 500 pages, he talked about there being no official discrimination 25 years later. The problem with going to North Carolina Central is they teach you how to go to the library. And when you go to the library, you hear that people use that same rationale for poll tax. They say, it's not official discrimination. This is just a political policy. All they have to have is money. It's not about race. Same language. If you go back in the annals of history, you also hear the same language. Well, Judge, this may be wrong, but the time is not right. You know, that got us in trouble with the Brown decision. Brown decision, May 17, 1954. Lawyers went back into court. I. Beverly Lake was one from North Carolina. Went back into court and argued, can't move too fast. Wait a minute, the law is separate but equal is unconstitutional. Yeah, but we need time. We need time. So we would like to recommend some new language with all deliberate speed. It's called Brown 2. contradictory words. You can't be deliberate and speedy. What did that do? It meant that the law said desegregation, 1954. Now, let me mess with Ms. Coleman. Ms. Coleman, you weren't executive director in 1954. No. She said no. but when you became executive director in the 70s, right? Yes. In the 67, whatever, didn't you have to work on desegregation? Oh. Now, wait a minute. She wasn't executive director in 54, but she's working on desegregation in 70s. Why? Because they said we got to slow down. We don't have time. Huh? I went to segregated public schools in Washington County because somebody said we don't have enough time. The right time to do right is right now. And there is no provision in the Constitution that says you may be being discriminated against, but if the time is not right. In fact, it's the exact opposite. Equal protection under the law is in the present tense, not in the past tense or in the future tense. It's in the present tense. North Carolina had enough time to mess up. They passed this bill in warp speed. They didn't allow for any public comment. They rushed it through to suppress the vote. We ought to take the time, if the federal court joins with us, to undo the suppression. Any others? Madam President, we've been here all in Virginia, and we locked in, and Deborah, we couldn't have done this without Deborah. Deborah, thank you, Deborah. You want to stand and say anything? And then, Madam President, and we're going to close out. Please talk to our plaintiffs here today, personal interviews, personal stories.
Good afternoon. To my president of Virginia State Conference, Linda Thomas, to my fellow board members, and to my NAACP family. We just want to welcome you here, and it was my honor and my privilege to be a part of this today. And we love you, and we are praying for success. And I tell you,
to Reverend Dr. Barber, to my extended NAACP family, sir, you are a learned man, a man of letters, so ain't no need me trying to out-intellectualize you. You are a minister of the gospel, no need for me to try to out-orate you. I simply say that as part of the NAACP family, as president of the Virginia State Conference of branches, I welcome you, and I just want to say, when they pick on family, it's everybody's fight.
Somebody said, everybody, fight. Everybody, fight. Everybody, fight. What do we want? Justice. When do we want it? Now. Curtis, what do we want? Justice. When do we want it? Now. Go.
What do you want?
Justice.
When do you want it?
Now.
When I say, what do you want? You say voting rights. What do you want?
Voting rights.
What do you want?
Voting rights.
When I say, what do you want? You say justice. What do you want?
Justice.
What do you want?
Justice. Yeah. God bless you.